Faith Chepkurui, Vivian King, Justine Baraka, Pauline Wanjiru, Naida Mbeyu, Jambo Jipya Medical Clinic.
Yes.
My name is David Appears.
Concerns of the church. So who is Mr. Naida?
Jambo Jipya is
So you're pleading for the clinic? In your place next time, I'll not be able to tell because I can only see your eyes. Yes, no. Madam, tunahitaji kuona pia vile unakaa. Uko na homa? Pia kuna homa sana. Hawezi kaa vile unaelewa Kizungu au Kiswahili? Count one and count.
count two. You know, I forgot to place my running friend Mr. Gishiko on record.
Okay.
We couldn't put together.
Mr. Gishiko is for which party?
For the first, second, third, fifth, sixth, and seventh.
Okay. How long will you take to argue the preliminary issue?
I'll take 5 minutes, then my running friends will be present for it, maybe approximately 10 minutes.
Okay. You are notified your colleague for the issue.
No, they have just served us with the charge sheet.
Okay.
We wish to challenge the jurisdiction of the court to entertain plea on count number 1 and count number 2 of the charge sheet on the following grounds: that the court lacks jurisdiction to entertain the said counts on section 44 of the SHA Act, section 2 of the Criminal Procedure Code, that is count 75. You know, the basis upon which these charges are construed arises from the transactions contemplated in the SHA Act. Indeed, Your Honor, the particulars of count 1 provides that on diverse dates between 1st November 2024 and 30th June 2025 at Jambo Jipya Medical Clinic, Mpwapwa.
Sorry, Mr. Naida.
Yes, Your Honor.
I have it. You don't have
Okay,
to write.
I'm So the transaction, Your Honor, involves a sum of 2,032,680, which is alleged to have been paid by SHA that is Social Health Authority. At count 2, Your Honor, the offense, at count 1, the offense is premised, or is that of conspiracy under the Penal Code. But the particulars of the charge speaks to the Mother Act. That is to say, Your Honor, the substantive law from where the particulars arises from is the SHA. Notwithstanding the fact that the offense emanates from the Penal Code. The court must draw that distinction. At count 2, Your Honor, the charge accrues from section 48, subsection 3 of the Social Health Insurance Act. The Social Health Insurance Act must be read together with the Social Health Authorities Act. They are merely, there can be none without the other. And therefore the count number 2 clearly indicates that the offense originates from the SHA Act. 44, Your Honor, of the SHA Act. It provides that there is established a tribunal to be known as a Dispute Resolution Tribunal for the purpose of hearing and I am interested with the deliberate use of the word complaint. That the Act also speaks about disputes and appeals in accordance with this Act or any other written law. Is the one that appears at count 2. Your Honor, it follows therefore that the deliberate use of the word complaint, it is the defense understanding that this is a term appearing under section 2 of the CPC. That is to say, Your Honor, section 2 of the CPC defines what a complaint is. There is no any other law in Kenya enacted by Parliament that directly defines the term complaint. And therefore, Your Honor, when the Act deliberately uses the word act as a complaint, it must be accorded the literal meaning. The literal meaning to mean, Your Honor, that this is a complaint, if entertained, would result into a charge sheet. Even if, Your Honor, you'd find that the literal interpretation would result into absurdity, then we can go to the golden rule of interpretation of that terminology. And we go to the golden rule so as to avert any possibility of absurdity if the literal interpretation leads us to that absurdity. And granted the fact that it's only the Criminal Procedure Code that has defined what a complaint is. It is our humble submissions that the terminology appearing under Section 44 of the SHA Act is a complaint defined by Section 2 of the Criminal Procedure Code. You know, the High Court had the opportunity of interpreting this word complaint. That is, in the case of Republic versus Mohammed, Ado Mohammed, 2013 EKLR, the High Court sitting at Mombasa had this to say. That is Republic versus Mohammed, Ado, that is ABDOW, Mohammed, 2013 EKLR. Complaint as a formal allegation under Section 2 of the CPC, and that's what Justice Hedwin Omundi. Again, in the case of David Joroge Masharia versus Republic, 2011 EKLR, this was a matter before the Court of Appeal. Justice Tunoi, Justice Jambo Otieno, and also defined what complaint is. Finally, in terms of the authorities, equally in the case of Republic versus DPP, ex parte, His Lordship, GPM, 2013 EKLR, Justice Mobi Ngugi, as she then was, defined as she then was, defined what a complaint is.
You have these authorities?
Yes, Your Honor, I can provide them. Equally, Your Honor.
You should be providing us your...
Yes, Your Honor, I ask my friend to help us get them. That is the definition that the High Court gave to the term, and the Court of Appeal gave to the term complaint. It is our humble submissions that what is before you is a complaint that our client, in one way or the other, offended. Is a complaint, it's an allegation that they offended the provisions of the law and hence the preference of count 1 and count 2. If therefore, Your Honor, we are right, and if the interpretation of the word complaint is right in accordance with the defense, then the person with the jurisdiction to entertain such a complaint is the tribunal. You know, that is also backed with the doctrine of exhaustion.
So it's not...
Equally backed by the doctrine of exhaustion, that before a matter such as this one gets to your bench, the person complaining ought to have exhausted the laid down mechanisms. look at the wording of section 44 of the Act, this tribunal is referred to as a dispute resolution tribunal. This tribunal, Your Honor, if I was to read the word of Parliament, Parliament must have been thinking or contemplating that parties to this particular act will ordinarily get into a contractual relationship. And if parties are therefore to get into a contractual relationship, there ought to be a less adversarial mechanism of resolving that dispute. Ordinarily, in contract law, such mechanisms is created so as not to sever the relationship between the two contracting parties. So humble submissions, Your Honor, that the ODPP has jumped the gun. This is not a matter that ought to have come before you. You know, if you find favor in our argument, it will be a humble plea that you decline the invitation by the ODPP to bend the law. Parliament could not have enacted section 44 without a purpose. You know, this argument is further backed up by the provisions of Article 10, 27, Article 48, and Article 50 of the Constitution. Article 10, Your Honor, invites you to apply the law and says that the principles and the values of governance bites every state organ whenever any of them applies the law, interprets the law. We are bound by Article 10. And the fundamental aspect of Article 10 that bites you is the question of the rule of law. That you are bound by the rule of law. If the law says X is what is right, then it cannot be Z. Article 10 equally invites you to be bound by the principles of the Bill of Rights, where Article 27 falls. That both the ODPP and our clients are entitled to equal protection and equal benefits of the law. And I'm not inviting the court to interpret the Constitution. I am inviting the court to apply the Constitution. And that is why Article 48 therefore becomes relevant on the question of access to justice. And therefore, you cannot access justice if you're not going to be given a fair hearing and a fair trial under Article 50. So in making a finding, in making a finding, you know, in our argument, we urge you to be bound by those provisions, but also make a further application, Your Honor, that our clients, pending the determination of our application, our clients be admitted to bail pending a charge. This application, Your Honor, again is done under Article 49 plus H, Article 49 plus 2H.
Sorry, Counsel.
Yes, Your Honor.
You are saying the court does not have jurisdiction.
Yes, Your Honor.
At the same time asking the court to make an order in the same matter.
You have suspects before you, and that is why Article 49 provides that a court can admit to bail pending a charge. Pending. That's why I was specific in quoting 49H. So that, Your Honor, Article 49H contemplates a scenario such as this one, where a preliminary issue may arise before a court of law, and a court of law then is invited to make a determination as to, in the intervening period, what do we do to the suspects? If I am right, and if I gather the court right, the subjects before you are under your jurisdiction, because they are before you. The court must make a determination as to what we do in the intervening period. That is to say, Your Honor, that the court cannot be helpless in the manner in which to manage the liberty of the accused persons in the intervening period. That is why Article 49 clause 2H provides for a charge, a bail pending a charge. And that is, Your Honor, not to be determined by the jurisdiction contained or challenged under the charge sheet. This court, being a chief magistrate court, has jurisdiction under Article 49 to admit an individual to bail or bond. I invite my learned friends, Your Honor, to further the argument. Your Honor, I will seek leave of absence because I have been replying to the ODPP. I am also obliged.
Where are you going?
I have a matter.
Your Honor, I do concur with the that this court has no jurisdiction in this matter. Your Honor, I'd like to cite a famous case on jurisdiction, and that is owners of the motor vessel Union S versus Caltex. That is owners of motor vessel Lilian S versus Caltex Kenya, which is a 1989 matter. It states that jurisdiction is everything. And when Your Honor, I would not like to belabor the point that my learned colleague has pointed out. I'd like to leave the floor to my other colleagues.
Your Honor, given that Mr. Ndegwa has submitted exhaustively, Your Honor, let me give the opportunity to the ODPP to respond, and then I'll have the floor on the rejoinder.
Your Honor has been told that this court has no jurisdiction to handle this matter, rather to take it. And they were corrected. His submissions were that this is a matter that should first be resolved at the tribunal. So that therefore should be a bar, or rather should bar the office of the DPP from preparing charges against the suspects before this court. Give us case notes, the famous case that she quoted, and indicated just that this court has no jurisdiction. Our submissions are that this court is clothed with jurisdiction to entertain the plea before this court. Of the Constitution, I will not repeat which subsections, but Your Honor, the office of the DPP is granted the power to institute criminal charges The Constitution also states that while exercising this power, the DPP will not be directed by anybody if the decision is made in good faith, the public interest, are the charges that we intend to prefer against the accused, but the suspects hearing is a clear indication that this is a public interest matter. The office of the DPP exercised its mandate and directed that these charges be preferred against the suspects before this court. Your Honor has when they needed to have given compelling reasons. The reason for rejecting the charge sheet cannot be on the basis that a tribunal can entertain this dispute as submitted. If a tribunal can entertain the dispute as submitted, you have not been told how cogent reasons have been given to you why the suspect before you should not take plea.
Just a quick rejoinder, Your Honor. Your Honor, let me start from the point of the Land Prosecutor's submission on Section 134 of the Criminal Procedure Code. Your Honor, I must say that we must distinguish what is provided under Section 134 Your Honor, and the arguments that we are making on behalf of the suspects before you. Your Honor, no argument has been made by the defense that the charge sheet, as is before you, is in any way effective. That is the purpose of any challenge under Section 134 of the Criminal Procedure Code. Your Honor, the argument before you this afternoon is that the court cannot admit the suspects to plea taking on account that this court lacks jurisdiction at the moment to entertain the charge sheet. Therefore, Your Honor, we ask the court to get that distinction. Your Honor, there needs to be that distinction on a defective charge sheet and the question of jurisdiction of the court admitting the suspects to plea today. Your Honor, secondly, today, Your Honor, is not that the old office of the DPP does not have the authority to prefer charges. Rather, Your Honor, it is that the charges that have been brought before you are improperly before you because the Office of the Director of Public Prosecutions and the Directorate of Criminal Investigations skipped a very critical step before they prefer the charge or before they say that there is an offense that is being alleged. Your Honor, a look at the discloses the complainant as the Social Health Authority. The main allegation being made, Your Honor, is that the accused persons through Jambo Jipya Medical Clinic caused the authority to make payment to them when they should not have made the payment, when the Social Health Authority should not have made that payment. Your Honor, as had been correctly stated by Mr. Naida Mbeyu, both the complainant, that is the Social Health Authority, Your Honor, and the medical facility, that is Jambo Jipya Medical Clinic, Your Honor, both are bound by the provisions of the Social Health Social Health Insurance Act, Your Honor. And as such, the first port of call for any kind of dispute will be Section 44 of the said Act. So that, Your Honor, if, as is being alleged, that Jambo Jipya Medical Clinic should not have received the payments, that is the dispute. And that is the complaint by the Social Health Authority. And as such, Your Honor, if the tribunal contemplated under Section 44 has Your Honor, if the tribunal contemplated under Section 44, and I can confidently say that has not even received this complaint from the complainant, then, Your Honor, there is no offense. The only body that can make a determination on whether that medical facility was paid within the province of the law the only body at the moment, Your Honor, that can make the determination on whether the payment made by the Social Health Authority to the facility will be the tribunal in the first instance. It is only then that it can be determined that an offense has been committed or not committed. Without that determination, we will fortify our submissions that the ODPP have jammed the gun. And at the moment, there is no offense, and as such, Your Honor, that you will lack jurisdiction to admit the suspects to take it. That is all, Your Honor. when I can pass over my phone, I have it open on my phone.
This one aside, deal with the other one? Or do you intend to raise the same issues in the other one?
The other one has not been called, but they emanate from the same similar facts. So we will be happy to get a call.
You want a ruling on the spot? Mr. Kihana?
Yes,
And your colleagues? You can see what is going on.
yes, this is actually very planned. Mr. Kizu.
The voters have been decided to write a ruling here. It will take me some time. So I can be writing my ruling in my chambers as you tell stories. I'll take about 30 minutes. So I'll be back in 30 minutes. In case there be extension of that, I will let the officer inform.
Thank you.
Data lunch. Ati ameenda kufanya? Hiyo ni moto.
Because now these guys are saying those guys should be charged like
Yeah.
so you know.
I have considered the submissions made and the rules of the judge. The point for determination is whether this court has jurisdiction to deal with counts numbers 1 and 2 of the body of the charge sheet filed herein. Count number 1 has been brought under section 393 of the Penal Code, while count number 2 has been brought under section 48 subsection 3 of the Social Health Insurance Act. Section 48 subsection 3 of the Social Health Insurance Act provides that, I quote, any person who, for the purpose of obtaining the payment of any benefit under this act, knowingly makes any false statement, whether orally or in writing, commits an offence and is liable on conviction to a fine not exceeding 1 million shillings or to imprisonment for a term not exceeding 60 months or to both. End of quote. And section 393 of the Penal Code provides as follows, and I quote, any person who conspires to commit with another, sorry, let me read it again. Any person who conspires with another to commit any felony or to do any act in any part of the world which is done in Kenya would be a felony, and which is an offence under the laws in force in the place where it is proposed to be done is guilty of a felony and is liable, if no other punishment is provided, to imprisonment for 7 years, and if the greatest punishment to which a person convicted of the felony in question is liable is less than imprisonment for 7 years, then to that lesser punishment, end of quote. The criminal jurisdiction of magistrates' courts is provided under Section 6 of the Magistrates' Courts Act as follows, and I quote, a magistrate's court shall have and exercise such jurisdiction and powers in proceedings of a criminal nature as may be conferred to it by A. Criminal Procedure Code, or B. Any other written law, unquote. The provisions of Sections 4 and 5 of the Criminal Procedure Code are as follows. Subject to this code, an offence under the Penal Code, Chapter 63, may be tried by the High Court or by a subordinate court by which the offence is shown in the fifth column of the first schedule of this code to be triable. Excuse me. Section 5. Any offence under any law other than the Penal Code shall, when a court is mentioned in that behalf in that law, be tried by that court, subsection 2. When no court is mentioned, it may, subject to this court, be tried by the High Court or by a subordinate court by which the offence is shown in the fifth column of the first schedule to this court to be triable. In Section 2 of the Interpretation of General Provisions Act defines court as follows. A court means any court in Kenya of competent jurisdiction, unquote. The general rule is that where a court has no jurisdiction to handle any matter, it must down its tools. That is the position stated by the Court of Appeal in the celebrated case of owners of Motor Vessel Lillian S. versus Caltex Kenya Limited, 1989 EKR. This is a criminal matter, and this being a criminal court has jurisdiction to handle criminal cases except those in which its jurisdiction has been expressly hosted. I have read the provisions of Section 44 of the Social Health Insurance Act, and I have no doubt that the tribunal established therein is not clothed with criminal jurisdiction. Jurisdiction to handle criminal cases remains with criminal courts, and that jurisdiction remains even where there is any civil matter already filed relating to the same set of facts giving rise to the criminal case. 193A of the Criminal Procedure Code, which provides, and I quote, notwithstanding the provisions of any other written law, the fact that any matter is issued in any criminal
You've been charged with conspiracy to commit a felony, contrary to Section 292 of the Penal Code. Particulars of the offence are as follows. On diverse dates between the 1st of November 2024 and the 30th of June 2025, at Jambo Jipya Medical Clinic in Tuapa, within Kilifi County, jointly with others not before court, conspired to commit a felony, namely fraudulent alteration and falsification of information, which led to payment of Kenya shillings 2,32,680 by social health authorities. Patrick and Kanya, this one. Faith Chepkurui B, this one. Okinyi and Justine Baraka, Justine Baraka, this one. Pauline Wanjiru, this one. Naida Mbeyu, this one. Jambo Jipya Medical Clinic, this one. Foreign Act of 2009. Particulars of the offence are as follows. On diverse dates between the 1st of November 2024 and the 30th of June 2025, within the established area, knowingly acquired Kenya shillings 2 million and 2,680 through family bank account number 005-0000-800953 from Social Health Authority, being processed and having reason to believe that the said funds were delivered from unlawful activity. Patrick and Mugan, this one. Faith Chepkurui B, this one. In count number 4, Patrick Kanya and Faith Chepkurui, you have been charged with use of proceeds of crime contrary to section 1 of the Proceeds of Crime and Anti-Money Laundering Act number 9 of 2009. Particulars of the offence are as follows. On diverse dates between the 1st of November 2024 and the 30th of June 2025, within the Republic of Kenya, used Kenya shillings 2,32,620 through family bank account number 005 0000 80953, but withdrawing through M-Pesa number 0724 936 368, being proceeds of crime, having reason to believe that the said funds were derived from unlawful activity. Patrick Kanya, this Faith Chepkurui, this in count number 4, contrary to section 353 of the Penal Code. Particulars of the offence are as follows. On diverse dates between particulars of the offence are as follows. On diverse dates between the 1st of November between the 11th of December 2024 and the 12th of December 2024 at Jambo Jipya Medical Clinic within Kilifi County, the means of fraudulent misrepresentation made Social Health Authority to pay Kenya shillings 30,000 by falsely claiming that Mary Njoroge had undergone a cesarean section in the facility, whereas in fact she delivered normally, thereby occasioning financial loss to Social Health Authority. Patrick Kanya, this one. Faith Chepkurui, this one. In count number 6, Stephen Okinyi was valid and genuine document issued by Jambo Jipya Medical Clinic. Pauline Wanjiru, this one. In count number 9, Stephen Okinyi was wrong. He had been charged with the offence of uttering false documents contrary to section 353 of the Penal Code. Particulars of the offence are as follows. On the last date between the 1st of November 2024 and the 30th of June 2025, in Jambo Jipya Medical Clinic in Mutsotso, within Kilifi County, knowingly and fraudulently uttered forged clinical notes in the inpatient file for Agnes Kisinda, the CEO, Social Health Authority, purporting to be genuine documents duly prepared for the said patient. Stephen Okinyi was wrong. Count number 10, Justine Baraka, who have been charged with the offence of uttering false documents contrary to section 353 of the Penal Code. Particulars of the offence are as follows. On the last date between the 1st of November 2024 and the 30th of June 2025 in Jambo Jipya Medical Clinic in Mutsotso, within Kilifi County, knowingly and fraudulently uttered forged clinical notes in the inpatient file for Lucas Mwamba, the CEO, Social Health Authority, purporting it to be genuine documents. Justine Baraka, is true. In count number 11, Pauline Wanjiru have been charged with the offence of uttering false documents contrary to section 353 of the Penal Code. Particulars of the offence are as follows. On the last date between the 1st of November 2024 and the 30th of June 2025 in Jambo Jipya Medical Clinic in Mutsotso, within Kilifi County, knowingly and fraudulently uttered forged cadets in the inpatient file for Agnes Kisinda, the CEO, Social Health Authority, purporting it to be genuine documents. Pauline Wanjiru, this one. In count number 12, Naida Mbeyu has been charged with uttering false documents contrary to section 353 of the Penal Code. Particulars of the offence are as follows. On the last date between the 1st of November 2024 and the 30th of June 2025 in Jambo Jipya Medical Clinic in Mutsotso, within Kilifi County, knowingly and fraudulently uttered forged claim forms for Agnes Kisinda and Lucas Mwamba, the CEO, Social Health Authority, purporting it to be a genuine document. Naida Mbeyu,
on behalf of the
Before
first.
you proceed further, I don't know whether you have any objection to mail or not. So that
Terms. Your Honor, further consideration could be made with regard, Your Honor, if the court will allow me to be a bit more specific. Your Honor, the charge where they all collectively charged is count number 1. Being, Your Honor, that they all allegedly conspired to commit the offense. That is where the specific figure of 2,032,680 is lifted to. Your Honor, for accused number 3, accused number 4, and then making that argument on behalf of Mr. Chol, if she permits me. And again, Your Honor, the 6th accused person, that is Naida Mbeyu. Your Honor, we note that they also appear independently in counts that relate to the uttering of false documents. Your Honor, on a wild speculation, I don't think that one set of documents is what will amount to the whole sum of the 2,032,680. And Your Honor, even as you ask for those leading terms, for those specific accused persons, Your Honor, I will ask the court that the court might consider setting valid terms for them. You know, having a look at the charge sheet and seeing the specific offenses that they are accused of. You know, as I've indicated, the accused persons, all of them, have been very cooperative with the police. You know, considering that they've been with authorities since Thursday, that is the 2nd of October 2025, and their cooperative nature, you know, will ask the court to be very, very lenient in setting the terms. You know, they do commit, just as they've been very cooperative with the police, they do commit to be appearing in court when they are required. And if their assistance is also required for any other reason by the police, they are ready and they will continue cooperating with the police. That is all.
Just to add on that, my client with the first accused person, that is Mr. Justin, just got recently married on 2 months back. The wife is in court. You know, this is a young family. I pray for the court to factor into the presumption of innocence of the accused person while awarding bail and bond.
You have been asked to give very, very lenient terms. We have, as earlier indicated, we are not opposed to the release. The accused persons on bail bond, but reasonable terms. You know.
so we have to ask them then. Unafanya kazi gani?
I'm a clinical officer.
Na huyo mwenzako 200 mtalipa, mtafanya kesi mkitoka kwenu. Case will be moving to High Court to seek transfer. We have done the necessary by then.
Yes.
Now where will we go? Yes.
You know, with regard to the specificity of the offense, given what the particulars of the offense indicate, I believe that as making that request for the transfer.
Once we transfer, we have transferred today. I have considered the submissions made by the council. The accused person solely enjoy presumption of innocence, though the nature of charges is consideration in determining reasonableness of bail on short terms. The first and second accused persons are granted bond of Kenya shilling 600,000 with one short in A above equally cover his position as the seventh accused representatives. The matter being mentioned for